SJC-12863, Marcos Garcia, the Commonwealth.
Okay, Attorney Huggins.
Morning, Your Honors. Elizabeth Huggins on behalf of Marcos Garcia. As this court is well aware, even temporary involuntary hospitalization can disrupt ongoing outpatient treatment efforts as well as ties to the community. The harm is real and tangible, and it certainly was for my client. In this matter, following a verdict of not guilty by reason of mental illness, Mr. Garcia was ripped from the community after being out for 10 months prior to trial without incident. He was denied of his liberty for 42 days without justification. There was no balancing test to consider his fundamental right to freedom against any government interest. My argument today is twofold. First, Chapter 123, Section 16A is unconstitutional because it provides no evidentiary standard justifying a commitment to a facility, nor does it provide a least restrictive alternative. Second, even if this court is to construe that the statute passes constitutional muster, the lower court in this matter failed to apply a constitutionally permissible standard, and as such, Mr. Garcia's involuntary hospitalization was unlawful. As the court is aware, 16A says that a court may involuntarily hospitalize an individual for up to 40 days following a verdict of not guilty by reason of mental illness. This court has found that even a 3-day hold is a massive curtailment of liberty. Such a deprivation of liberty requires due process. Yet as it stands, 16A allows for automatic commitments, not mandatory, but permissive automatic commitments. And it says that anybody may be committed. That includes individuals that are on wait list, participating in outpatient treatment programs, as well as those that are not guilty by reason of mental defect, that they have a cognitive disorder.
Isn't there a sense, though, that it was Judge Allman after the lack of criminal responsibility verdict, right?
Yes.
So, and I know the quote that you took out from his statement about not being comfortable, but he just heard the entire trial, and the circumstances were that your client, Mr. Garcia, was sort of in a similar position than he was before the episode, the carjacking and the chase and everything. He didn't have medication, and he wasn't in a program. And why do we assume from that one statement that a very thoughtful judge didn't take into account everything he just heard, recognize, because you have to be right, being held for 40 days is a deprivation of liberty. I mean, come on. That he that he took that all into account and made a decision that there should be not a commitment, but an evaluation at a hospital as it relates to these issues.
Because I think what Judge Ullman was focusing on was twofold. One, he was focusing on that the two experts didn't have a meeting of minds as to what the correct diagnosis of the individual, and he was speaking particularly to what the appropriate mental health treatment here. The problem with looking at that alone is that it's avoiding looking at the loss of liberty. And here, Judge Ullman did find that there was no likelihood of serious harm, but he said that that standard only applied to Bridgewater. It didn't apply to a commitment to a facility. And I think that that indicates that he wasn't taking into consideration. Moreover, you know, when we're looking at the facts of the case, yes, they can be considered for sure. But again, the factual questions at trial are very different than the factual question at whether or not somebody should be confined for mental health reasons. And I think that at trial, you're looking back here 19 months as to Mr. Garcia's state of mind. The time of trial, you're looking to his state of mind at that time. And here, he'd been out of custody for 10 months. And yes, he was unmedicated, but he'd been unmedicated for 5 months. And I think that the problem with 16A is that it has a flavor of punishment. And here we're talking about punishing somebody by depriving them of their liberty without a greater justification than just treatment. And I think that that also goes to why the statute is unconstitutional. There's no least restrictive alternative. There's no ability to do one of these evaluations outpatient. And so here, Judge Ullman involuntarily hospitalized Mr. Garcia, despite the fact that there was no eminence met by the Commonwealth. He did find that there was no likelihood of serious harm, but said that that standard only applied to Bridgewater. And I think that that goes to the issue with the statute in of itself, is that there is no standard applicable to those that are facing commitment under 16A.
Is there any way to save the section in your view?
I think, as I suggest in my brief, that if the court, and I suggested this to Judge Ullman at trial, following the trial, is that you have to apply the only standard of evidentiary standard in this chapter, which is in section 1, likelihood of serious harm. With that said, it doesn't solve the least restrictive alternative. If the court looks at chapter 15A, there is a least restrictive alternative. And I suppose the court could do that, but as it stands now, unless the court was to interpret that there is a least restrictive alternative, allowing for an evaluation to be done outpatient, I think that that are the two key issues here. And as the plain language of 16A, there is no least restrictive alternative. But I would say at the very least, the court would have to read in that the standard is likelihood of serious harm, even to a facility.
So given that, let's assume that we agree with you that there needs to be a likelihood of serious harm. How can we really salvage this statutory provision if in fact that the statute itself says that's the standard only for Bridgewater?
Well, I think that we use canons of statutory interpretation. We look
right, and one of those is words mean what they say, right? So if there is an absence of words in a particular provision and the presence of those same words in another provision, I don't see how we can add the words that are specifically absent.
Well, I think that there's also the standard that says that where language of one section closely monitors the language of another section, the court can read in that a standard exists. And I think we can also read in to the legislative intent. It was clear that in 1970 that the legislature intended to do away with automatic commitments and provide greater due process of law. And I think that this is just a vestige of that old law that has not been addressed previously. And I think that it goes without saying. And I think the other thing that can be done is that if you look at the standard for Bridgewater, there is an additional requirement. And well, there's two additional requirements. First, the individual has to be male. And second, there has to be a showing that strict security is required, where that wouldn't necessarily be true to a DMH facility.
So you would import 16B into 16A?
Yes, and that's what I think is done in practice. Dr. Bonagorio testified to this effect and said that there was no standard associated with the 16A evaluation, so they looked to the standard of 16B.
You would say under 16B, I think this might be the point you were making, let me know if it's not, that under 16B, there could be still a concern that requires hospitalization, obviously, but just doesn't require hospitalization at Bridgewater. Doesn't require the strict security of Bridgewater.
Correct. And I think that also, by looking at 16B, solves another issue here, which is also that 16B is very specific in that you have to be mentally ill and there has to be a likelihood of serious harm. And thus, as 16A stands right now, those that are not guilty by reason of mental defect, by cognitive issues, can be hospitalized under 16A, but not under 16B. And I think that's also probably inconsistent with the legislative intent. And so I think that is further reason as to why we should be looking at the standard in 16B and throughout the rest of the sections of chapter.
I'm sorry, I thought the general definition of mental illness in the statute required a so-called defect. So someone that had a cognitive issue would not be categorized as mentally ill.
Correct.
And organic brain dysfunction, for instance.
Correct. And so I think we agree. And that's what you see under 16B, where 16A would allow, because it says...
Right, that's why I'm missing that gap, because I thought the overall definition, maybe it's the DMH definition of mental illness, because we've had this before when someone had a cognitive dysfunction. There's no place to put them because they're not mentally ill under the statute. They have an organic brain disorder. Do you think someone that has an organic brain disorder could be evaluated under 16A?
As it stands now, yes, I think anybody could. I think. I don't think there's any restrictions on 16A whatsoever, which is, I think, precisely why we're here, is that there's no limitations, there's no due process requirements for anybody that's in treatment or anybody that with the cognitive deficits that you've illustrated. And so go ahead.
No, please finish your answer.
You get my question. Thank you.
No, that's a,
But then if Justice Graziano's question's answered, even though, we're supposed to have some reticence to reach constitutional issues that we don't need to, and there's implications for 16A when it's competency and maybe even 15B. If we reach this issue, you sort of talk about proof beyond reasonable doubt and probably recognize that's not going to happen and talk about clear and convincing evidence. But this is to determine whether or not somebody needs to be committed. This is trying to give the judge the information he or she needs to decide whether to have a commitment. Is clear and convincing evidence really required for that?
I think it is here, particularly where this court has found that clear and convincing evidence is necessary for even lesser holds, for Section 12, Section 35. Here, my client was found not guilty. He was acquitted. He's legally innocent. And thus, we don't punish the mentally ill. So I think that there has to be some showing. And I think clear and convincing evidence is the minimal quantum of proof here, because you're talking about a 40-day hold. And so I think that it's completely appropriate, in particular with cases like this, where the individual has been acquitted, found not guilty. He should be in no different of a circumstance than those facing a less significant hold. And so I think it's absolutely important. And I think that also sort of touches on the fact that had the Commonwealth moved forward on their 16B motion, Mr. Garcia would have suffered a significantly shorter period of time in the hospital. Under 16B, he would have been entitled to a hearing within 14 days that the Commonwealth could not have extended, that a hospital could not have extended. And I think undoubtedly that we can see now, hindsight's 2020 from Dr. Luber's report, that he, in the standard at that 16B hearing, would have been beyond a reasonable doubt that he would have been released. And so I think that having clear and convincing evidence as the gatekeeper to 16A is completely appropriate here, especially given the significant period of time that he is being deprived of his liberty.
If 16A was only a deprivation for a day to conduct the evaluation, what would your argument be in terms of the standard of proof?
In terms of the standard of proof or the quantum of proof?
Right. Well, both, frankly. I mean, if all we want is, as Justice Lowy is suggesting, that we give the judge the information that he or she needs in order to determine whether a commitment is in order, it seems to me the problem with 16A is the 40 days, not so much the standard or the quantum of proof, but the fact that it's a 14-day commitment, a substantial deprivation of liberty.
Right, and I think that if we had something like 15A, which is a bit of a gatekeeper that allows for evaluations to be done in the courthouse by a court clinician, we wouldn't be here at all. And so I do think that, there you wouldn't necessarily have to have the same balancing act. But I think the moment that you're talking about confining an individual, especially for 40 days, which is what 16A stands for right now, is that you do need a higher quantum of proof, and you do need an evidentiary standard. And
we're rewriting the statute, assuming we rewrite it to import a standard. Which do we edit, the 40 days or the standard of proof?
Well, that's a great question.
Well, thank you.
I think both, honestly, because if we're talking about strict scrutiny, you need a least restrictive alternative in addition to the due process and to having the balancing test. So if we could eliminate the 40 days and allow for an evaluation to be done in the courthouse, then that would solve that issue. But if the 40 days remains for those that are going to have the full 16A evaluation in the hospital, I think there still has to be a balancing test requiring the evidentiary standard and quantum proof.
Well, counsel,
We can't edit the statute, though, can we?
No.
We would have to just say this is unconstitutional or whatever problem, and the legislature would have to start over if they got around to it.
Right, and that was what I was trying to outline in the beginning with the issue of the least restrictive alternative
Right.
and the lack of a 15A gatekeeper allowing for this to be done outpatient. That's, I think, the biggest issue to overcome here, where I think canons of statutory interpretation allow this court to read in that likelihood of serious harm is the appropriate evidentiary standard. I think the problem here really is the least restrictive alternative.
So this sort of leaks into the how this case got here and adequate alternative remedy issue, although I'm not going to ask you about that because your answer is quite simple, which is that Justice Kafka reached the merits. But how did this issue go all of this time without being adjudicated?
I think these circumstances are unique. I'm a trial attorney. I'm not an appellate attorney. I definitely have had these sort of cases, and I've worked with many colleagues. And I think the truth is, to have a client in a superior court case where you don't have the appellate division of the district court to review these sort of proceedings, it's very rare to have somebody who is out of custody and not facing a commitment, or who hasn't already been committed under 15B and 15C. And so I think that that is probably why the circumstances have taken so long to reach this court, because I think the circumstances here are unique. But I would say that I think that it's also often not pursued if the individual is out of custody. I think it was a combination of the facts of this case and the fact that Mr. Garcia was out of custody. And so that's my honest take on it.
Thank you very much.
Thank you.
Attorney Roll.
Chief Justice Budd, good morning. Good morning, Associate Justices of the Supreme Judicial Court. My name is Ryan Rawl, representing Middlesex County and the Commonwealth. Your Honor, the case before you starts with counsel having a fundamental conflation of the statute under 123 with involuntary commitments of hospitalization and examinations for orders of observation and treatment. And that directly plays into the question of whether Mr. Garcia received sufficient due process in this case, which he did. I want to start first with pointing that the trial judge and as well the single justice did not abuse his discretion in denying this petition for extraordinary relief, where the trial judge committed no clear error of law or abuse of discretion. And I think it's important to start with discussing what due process Mr. Garcia had. He had an adversarial hearing. He had an opportunity to cross-examine and a direct examination of Dr. Bonagorio and present evidence about his present mental health treatment and medication, if there was any. And in this case, there was a
Before you get into those details, how do we measure whether there's sufficient due process or an error of law or an abuse of discretion if we don't know what standard to apply?
So I'll start with Your Honor addressed this a little bit on talking about how the trial judge had just witnessed the entire trial, which was an entire factual endeavor, which involved a series of armed carjackings in which there were two doctors who opined that he lacked criminal responsibility due to a chronic substantial mental illness. And so the court already has a large amount of information before it in the triggering event, whether it be an incompetency finding under 16A or whether it be a verdict of not guilty by reason of insanity. There was a lot of information factually before the court at that time. And so you start with the premise that the court is not a mental health professional, as the appeals court has recognized in Commonwealth versus Johnson, and is dealing with complex mental health cases, has a large amount of information, but it's always incomplete. And if you look at the statute as a whole under Chapter 123, it's best looked at as two distinct areas. The examination areas, which you see under 15B, 15A, 15E, and 16A, which have to do with aid and sentencings under 15E, competency evaluations on inpatient hospitalization under 15B, and then here, after a finding of incompetence or an NGRI, a inpatient hospitalization for examination and treatment. And then there's a secondary part of the statute which has to do with commitment. Now,
I understand. So, and we talked a lot about that difference, and we talked a bit about what the judge could have relied on. But I mean, there may be an answer to this question. I just honestly don't know it. How do I measure how much due process is due? How do I measure whether there's been an error of law or whether the single justice abused his discretion if I don't know what standard to apply?
and I think that rolls right into the due process question itself, which I understand. And the question in any due process analysis is sort of the risk of erroneous deprivation of liberty, balancing the compelling and legitimate state interests that are specific to examinations and not to commitments, and balancing that against the individual rights of the defendant. So I would first suggest, as I did in my brief, that this is sort of insufficiently brief, that it's difficult when Mr. Garcia is only concerned under the statute with NGRIs, whereas incompetency issues present completely different due process concerns and issues. But as I address in my brief, the question in examinations, whether it be 15B or 16A or 15E, is fact-gathering exercises. The court's trying to gather information to fulfill the purposes of the statute. And that is distinctly different than involuntary hospitalizations for 6 months and then—
How is that different from involuntary hospitalizations when, from the defendant's perspective, it's committed time, 40 days here? Whether you call it for evaluation and observation, or whether you call it a commitment, from the defendant's liberty interest perspective, he's confined for 40 days, 42 here.
And so that's certainly—
Why does it matter what the legislature calls it?
I understand that, and I agree that what the legislature calls it doesn't dictate the result, but it's not just the amount of time that passes, which could be as short as 10 days, depending on if a full 15B examination was done with the 20 days and then additional 20 days, because there's a cap under 16A to not go above 50 days between those two evaluations. So between 10 to 40 days, assuming that it takes that long or is necessary for the examination, I acknowledge in my brief that's a deprivation of liberty. That's part of the consideration. But just as this court found recently, in terms of setting an unaffordable bail and declining to put a standard of clear and convincing evidence on that, you have to balance what the interests are of the examination that are distinctly different and how they fulfill the statute than from a commitment. I think the examination process has a couple of compelling and legitimate state interests that are distinct from an involuntary hospitalization, which is that the court is trying to have objective, independent evidence about the questions of rehabilitation and protection of the public. It's trying to garner information that provides helpful information and make sure that someone has access to the care and treatment of the Department of Mental Health. And as sort of outlined in 15C, which describes sort of what is required for examinations, there is a requirement that there be an opinion about whether or not an individual is in need of care or treatment of the Department of Mental Health. And the overarching statute is designed to make sure that people who have significant mental health issues, whether that involves criminal responsibility or whether that involves competency, have access to services of the Department of Mental Health, and that the court has objective, updated, sufficient information to make sure that the goals of the statute are met, which is rehabilitation of the person and protection of the public.
But what metric, I guess, going back to Justice Lowy's question, I'm gathering information, I want more information. How do I determine whether the additional information is sufficiently needed to deprive this defendant of his liberty for 40 days? What metric are you using for that test? And then on appeal, how do we determine whether the judge abused her discretion or made a clear error of law if we don't understand the metric.
Well, so I think Justice Ullman, I think appropriately, made an attempt and did, I think, a great job in attempting to figure out in separating the difference between a 16A examination and a commitment, understanding that substantial risk of imminent harm is not a standard that could be.
I have no doubt that Judge Ullman did a great job in the absence of a statutorily prescribed test. I'm asking you, why is the statute constitutional if there's no test? How if I'm a trial judge, do I determine whether there's sufficient quantum of proof in order to commit a defendant for 40 days so that I can get more information?
This is also why I address in my brief what I believe the quantum of proof would be based on balancing all of those interests and attempting to come to a situation if the court felt that it was necessary to supplement the statute. As an initial statement, I would say that the triggering event based on choosing an affirmative defense of not guilty by reason of insanity or based on an incompetency finding with a substantial mental illness with concerns about the protection of the public and rehabilitation of the person with the additional piece there about competency restoration as being a potential issue. I think the scheme as a whole, where you provide the full due process protections for any commitment, for any hospitalization process, but that you have a lower standard to have them examined in the first place in the court, without a low standard, without broad discretion to trial judges to examine defendants at various stages of proceedings, it would impair the fair administration of justice. It would impair the ability of trial judges to make fast and difficult decisions in complex mental health cases without the assistance of objective professionals.
If you could please give us a standard then, because Mr. Garcia seems to ultimately say clear and convincing, and you've given us this dichotomy between examination and commitment, but it seems that you recognize that there has to be a standard. What's your standard?
So as to the quantum of proof, I suggest that the highest standard that could be argued is preponderance of the evidence. I would suggest in the language I used in my brief mirrors somewhat the language that's used in 15B, in that if there's reason to believe that somebody needs the care and treatment of the Department of Mental Health, that an examination can be ordered. And I didn't pull that out of thin air as counsel suggested in her reply brief, but actually 15B specifically says if the court has reason to believe that sub-observation and examinations are necessary, in that regard, it has to do with questions of competency or criminal responsibility before there's a finding. And if one reads that section, that examination, and then reads 15C about how that includes a requirement of an opinion supported by clinical findings, whether or not someone's in need of care and treatment by the Department of Mental Health, what you start to follow through with the examination process is that it's designed to make sure that people have access to the Department of Mental Health resources, and it's designed to make sure that if the court has reason to believe that someone may need those services, that they be examined, that they be observed. And so recognizing some of the issues that were raised by Justice Gaziano, for example, regarding intellectual disability, there are things under the standard that I suggest in my brief that would be an abuse of discretion. I'll give an example. There's a temporary psychotic disorder known as delirium tremens caused by alcohol withdrawal. It's a temporary psychotic disorder. It causes someone to completely lose control, but then it goes away. It's actually one of the few temporary psychotic disorders that exists rather than chronic psychotic disorders. And if someone had delirium tremens, assaulted someone in a hospital setting, for example, and was found not guilty by reason of insanity, at the time of trial, there would be an abuse of discretion to send them for examination because of the nature of the mental illness. So the factors I see.
What if, let me just play out your standard for a moment, which I think is that more likely than not, there's a showing that there's reason to believe that there might need to be a commitment. Doesn't there have to be some demonstration somewhere that they that they need to be held in order to have that examination to satisfy due process?
Well, so under the current statutory scheme, no, but I ponder that your question is whether there should be. And the problem we get into in that scenario is that an NGRI finding, just factually, is that the court loses jurisdiction after it orders or doesn't order under 16A. So once an NGRI finding happens, the only process that the court is allowed to institute is either a 16A examination or not. It's separate from 16A. Under 16B, the Commonwealth or the director of Bridgewater or the superintendent of a DMH facility can petition for commitment within 60 days. But there's nothing that allows the court to control an individual or order an outpatient treatment at the time of an NGRI finding. The limited authority of the court under the statute is just to order a 16A examination or not. So
I understand the problem, and that's a serious problem, because the person might need to be examined, and they were just found not guilty, even though the not guilty was lack of criminal responsibility. But if there is, more likely than not, a reason to believe that they need to be examined, that means they can be deprived of their liberty for up to 40 days without any demonstration that they need to be inpatient to have that examination.
So I understand that particular concern, and certainly if the legislature saw it in its wisdom to add an outpatient basis that had authority, I would suggest that the reason the statute exists as is, I think, is in large part because of the understanding of what happens after an NGRI case and the need for it to be inpatient because there's no control or jurisdiction over the person after an NGRI finding. But I would also point that the standard is not a rubber stamp that I'm suggesting. It would allow counsel to have an in this case, actually, the counsel did have an evidentiary adversarial hearing to present evidence that somebody, the nature of their mental health condition, whether or not they're currently receiving treatment or medication, whether or not they're currently a Department of Mental Health client, whether or not they're, and the full circumstances of the NGRI finding or incompetency finding that just occurred. So in terms of what factors the court could consider in sort of crafting an analysis under the statute, it's the very things that this entire statutory scheme is designed to look at, which is the nature of the mental illness and whether or not someone is in need of care and treatment, or whether there is a question of whether they need care and treatment of the Department of Mental Health. And again, this doesn't preclude in any way from the Commonwealth filing its own petition, even while the person is being sent for observation. And as in this case, the observation, the examination period satisfies its own prevention of erroneous deprivation under a commitment under 16B. So in this case, for example, Mr. Garcia's evaluation by Dr. Lubin provided updated information that specifically would have made it an uphill road for the Commonwealth to ever file a petition under 16B, because the hospital specifically opined that he didn't meet the criteria for hospitalization. That didn't preclude the Commonwealth from filing its own petition under 16B, but it was certainly a factor. And allowing the court to be able to have people examined and provide updated, objective information about whether or not someone needs care and treatment, not just hospitalization, but care and treatment generally, it prevents erroneous deprivations of liberty under the larger commitment statute under 16B and C. So respectfully, I'd suggest that, I see my time is up, so I would suggest that the defendant's petition should be denied, and I yield the rest of my time to brief unless someone has any questions.
All right. Thank you, counsel. We'll be in recess.